So just a few things about, I kind of start my First Amendment class talking about, kind of how do you kind of get into a free speech case? What's the kind of overall framework to kind of understand free speech cases? And the first thing you have to have, as we always talk about, is you have to have state action. The government can violate the First Amendment. Private actors can't. St. Anselm's College can't violate the First Amendment. So it can impose, I'm sure it has academic freedom principles, of course, but it's not subject to the First Amendment as a legal matter. So you have to have some kind of government action on the part of the federal, state, or local governments before you even have a free speech problem in the first place. And then it so happens, I'll talk a little bit more about this in a second, but that the tradition of the First Amendment has recognized categorical exceptions to free speech. Of course, this is a kind of an easy way kind of to understand some of the train of the free speech clause is that not everything is protected, and we kind of intuitively know that. And historically, the exceptions from free speech, from protection of the First Amendment, have been fighting words, true threats, defamation, commercial speech, although since the 1970s now commercial speech, that is advertising speech and the like, now has some measure of constitutional protection, obscenity, and, sorry, I misspelled that, and crime facilitating speech, so perjury, conspiracy. If you engage in speech that's a criminal conspiracy, that speech is not protected by the First Amendment. And so that's all pretty straightforward. And of course, there are a lot of cases delineating what those categories are, but those are the categorical exclusions from free speech protection. And then the next question to ask is, in what capacity is the government acting? Most free speech cases involve the government acting as a regulator, imposing a fine or criminal punishment on people for exercising their speech. But then there are lots of cases where the government acts as a landlord, a property owner, where the government acts as an educator. I'll actually, the next couple of days, be spending time with students looking at student free speech cases, free speech in schools and universities, and when the government is a subsidizer of speech. But a lot of cases involve that first category where the government is operating as a regulator. And then this gets a little bit in the weeds, but it is important. In the law of the First Amendment, now for many decades, we talk about the tiers of scrutiny. As I tell my students, kind of like Starbucks, there's tall, grande, and venti scrutiny. So at the lowest level of scrutiny, some laws only get rational basis review. The paradigm example of that would be economic regulation since the New Deal era is only subject to rational basis review. If someone brought a constitutional challenge to say to some tax provision or something like that, with some exceptions, that'd be just subject to rational basis review. And then there's intermediate scrutiny, which, as you might guess, is intermediate between rational basis and strict. But this is really where a lot of free speech jurisprudence takes place, is around this question of when the government has to satisfy strict scrutiny. And that is to say, when the government has to show that a regulation of speech serves a compelling government interest and is narrowly tailored, is no more restrictive than is necessary to achieve that government interest. And that's an extremely demanding standard for the government to satisfy. The usual phrase is strict scrutiny is strict in theory, but fatal in fact. It almost always means that the government will lose. So anytime a case comes up before the court and the court says, we're going to apply strict scrutiny, the government's almost always going to lose outside of a few small exceptions. But this turns out to be a very important aspect of free speech jurisprudence to figure out kind of what level of scrutiny to apply to a regulation on speech. And again, when it's strict scrutiny, where the government has to show compelling interest and narrow tailoring, it will almost always be the case that the government will lose those cases.